Nanti memang si dengan air right? Nanti ready memang not correct. Okay. Differences in the PC, additional PP, switch on camera. Okay. I shock. Okay. Am I audible to both of you? Yes, ma'am. Yes. Okay. So the judgment, I'll pronounce the judgment. Yes, ma'am. Who's the judge? Okay. The charge, claim against the accused, whether he has raped the victim on 4/2/2025 at around 9 p.m. are clear. I got confused. There are some portion is written as clear cut. There are some portion is written as clear cut. So I've written both together. Clear cut or clear cut. Okay. Can you tell me which is the actual? Okay, nevertheless. Okay. The charge frame against the accused is whether he has raped the victim, he withheld on 4 February 2025 at around 9 p.m. at Create Car or Create Car Station Maukarwang to liable him under Section 64(1) BNS. I've gone through the evidences on the court. No doubt, testimony of the the prosecuting statement need no corroboration, provided if it is unimpeachable and beyond reproach. Okay, but then I have also took guidance from the judgment in Rajdeep ISD versus State of NC Delhi, how to appreciate prosecuted statements, whether she falls in the category of sterling or whether there is exaggeration, whether the evidence is assailable, for which we'll have to seek for corroboration. Okay, with that guidance, I have gone through all the prosecuted statement, right from the initial stage till his last till her testimony before the court. Having gone through her prosecuted statement, it is seen she changes version from one stage to another. Not only that she changes versions, she brought exaggerations. Those exaggerations which looks like, which apparently appears to be improvised, where she even made up stories. Yes, of course, there is a ruling also which says if any variation or exaggeration, it can be ignored. If it is just to make up a good case. But in the facts of this case, the exaggerations and variations is so much with so many made up stories and the stories which are non-believable about mention of human hunter, how here in the RPO, which she toppled herself in her cross-examination, that she has no fear at that place of incident of occurrence. She toppled. Not only that, she brought me out stories which are unbelievable, impracticable, and non-viable, but she also coupled her own evidence. She contradicted herself. Okay. initial statement, she said she got the medicine from the sumo driver, medicine for son. She had gone to Clear Cut to get a medicine for son from the sumo driver, which they used to ask them to get in village. They used to do like that. She got the medicine from the sumo driver. Sometimes she said pick-up driver. Sometimes even vehicle is changed. She said at 7 p.m. she got, but she stayed back at the station till 9 p.m. She did not explain about the 2 hours gap, why she was there in that station. Because her purpose is simply to go and take the medicine for her son. Later on, she changes, she improvised, she improved the statement in her latter statement when she said, at times she said, I got medicine at 8 p.m. At times she said, I got medicine at 9 p.m. She brought stories that the vehicle, the sumo vehicle, they used to bring drinks for the people in the village. So she had to wait for her turn to get the medicine. And she changes version, nevertheless. Even her allegation in the course factor, she changes version from one to another, from one stage to another. In the first stage, the beat had raped. Then she brought in the subsequent stages that he even did other things, sexual assault, penetration, not only in her private part, even in her mouth and not. She keep on improvising. The prosecutor's statement in so many ways is found improvised, contradicted. She contradicts from one statement to another. She changes version. It is not safe. This court found her to rely solely on prosecutor's statement is not safe for conviction of the accused. Hence, will have to seek for corroboration. Since the mother, even the prosecution claimed that the victim's son and his friend Rishal, they were the eyewitnesses, because the prosecution had based on the prosecutor's statement, who claimed that these two have found her with the accused at the spot. So I've gone to the evidence of the victim's son. While going through the evidence of the victim's son, it is also found he contradicted his mother. Mother said, while the accused was on top of her, while he committed the act and he was on top of her son came and found them. Whereas the son said, when I reached, I had gone with he said he came to fetch his mother because she did not arrive home, or she was late to arrive home. So he went with the friend to clear the car station. At the station, his friend said, you go ahead, while he stayed back in the shop of somebody, empty shop of somebody. So the son went to the place where he heard some crying of a woman. When he reached at the spot, he saw the accused was holding his mother from the back. So he contradicted the mother, who said that the accused was on top of her. So the son said, no. I saw the accused was holding her from the back. On seeing him, he pushed his mother and he covered it by his hand to his face and fled away. But the very son, the victim's son, in his own cross-examination, he toppled his own evidence here. When he stated, it is a fact. He admitted, it is a fact. I have only seen the accused sitting with the mother, and they were talking, and I did not hear what they were talking. So is sitting together a sexual offense? It has no sexual, it don't show the sexual act. And this version of the PW2, which is the son of the victim, is seen that he stated this admitted fact even in his statement to police and statement to the magistrate. So, in such situation, the son did not support the prosecutor's statement. His friend, the PW 7, his friend Rishal, the PW 7, he also was found to have contradicted He contradicted himself, he contradicted the victim's son, he contradicted even the prosecutor's statement. And he brought fresh facts in the case. Because why? Before, in the initial statement before the police and in his statement before the magistrate exhibited during his evidence, where he stated, in this, okay, if I will ignore what he said to the police, but he said it to the magistrate that he never stated about the fact he brought in evidence before the court that he had seen that from the station he asked the torchlight from the victim's son and flashed to the jungle, and he saw at the spot he saw the accused with the victim, but then he did not see he saw the accused doing any act. He just simply said, I've seen the accused with the victim. In itself, it's not incriminating. Nevertheless, he said he had seen the victim and the accused when he flashed the light to the jungle. That is why he felt embarrassed. He gave the torchlight to the victim's son and asked the victim's son to go ahead down the slope, and he even explained where. And as per the friend of victim's son, he said he had seen while flashing the light, he had seen from a distance of about 10 to 12 meters, which is very short distance. Whereas the victim's son, he said he had gone from that point where the friend told him to go to that spot, which is about 40 feet. So even in this sense, there is a very big gap. Nevertheless, so if the victim's son's version is true, then it is doubtful how his friend could see from that far distance at the accused person. Nevertheless, this friend of the victim's son, he toppled all his evidence at the end of his evidence, at point number 11 of his cause, when he admitted the fact that he never stated having seen the mother with the accused to the police or to the magistrate because he felt shy. So whether a fresh fact brought in evidence can be taken, it cannot be taken. It cannot be relied upon. Okay? It cannot be relied upon. Besides, this victim's friend, he even stated in his statement before the magistrate, which is exhibited in evidence by the prosecution, that when the son brought the mother, when the son brought his victim mother to that place where he was, and when they reached home, it is the mother who asked him about the identity of the person whom he had seen them had tea in the shop. So it means the prosecution relies on the victim's son's friend, PW7, that he is the eyewitness, is found contradicted now, because this victim's friend, the son's friend, he gave it. He revealed the truth. That it was on asking of the mother, who was that person we had tea? Then he said it is follows the accused. Then it means it's a made-up story. When he brought, it's a fresh fact that he brought in the court, but which is also a made-up story. It is not reliable. So I have seen here the only crucial witnesses of the prosecution who were present at the PO. That is the victim PW1, her son PW2, and the son's friend PW7. These are the only three witnesses, crucial witnesses. But they made up stories, they exaggerated stories, and they contradicted each other, and they toppled even their own evidence with their admission at the last moment. So having found like this, I have to see from the medical evidence whether it left assurance. On going through the medical evidence, of the doctor of PW, PW9. He said he found nothing abnormal on physical examination, as because the victim had come to him for medical examination on her own, not through police, because she had not lodged FIR at the time. She had come for a medical examination after 2 days and 14 hours. So there is a gap already. Nevertheless, but if there is a sexual violence on her by an unknown man, because the victim gave a very peculiar identification. She said, I could identify the accused because I had seen him when I was 11 years old, when he came to his brother's, to her brother's house at Nong. And at this time, at the time of incident, she was 35 years. There is a big gap of 11 to 35 years. And as per the Resmi, the age of the accused is very young age, at around 34, 35. So which means if you minus that, if you calculate from the time he was seen by the victim in his brother's house when the victim was 11 years till his age of 34, 35, it means he was in the adolescence age when she had seen him. So during adolescence age, from age 12 till 19, due to puberty, there is a change in appearance in every person's appearance bound to have a change. There is a change. Then how is it possible for her to still remember the appearance? She claimed that he bears the same appearance when she had seen him when she was 11 years old till that she never seen him then at age of 35 when he committed the act. She had seen him, he bears the same appearance. That is impracticable and non-viable. Okay. Yes, of course. I will not deny the fact. Sometimes, genetically, due to genetic, sometimes a person still retain the same appearance, but that will be so only when the person's crossed a certain age. But in adolescence age, person is bound to change their appearance. This is my opinion. If you have a different opinion, there is a forum for you to approach. Okay. So the doctor also said, I found nothing excepting. I found no bleeding, I found no injury, I found no bruise, I found no nothing. Everything is normal, excepting mild congestion in her labia minora and the absence of hypertension. We have to take note of the fact that she is a married woman naturally, and mild congestion. The doctor admitted such can also happen due to other activities, or it could happen also due to infection. In the facts of the case, if sexual violence is there, but still no injury on her appearance, she is an adult at age of 35, as similar age would accuse. So there is some doubt here. This case might be a sexual act, if there is any sexual activity at all. But even the medical evidence cannot give accurate reliance. There is a benefit of doubt from the medical evidence. And the prosecution, as disputed by the defense, the prosecution has not brought the scientific expert as because there is a negative report. So even there is no scientific support to the prosecutor's statement in this case. Okay. While the rest of the evidences of those staff nurses is used to discuss, since scientific evidence is not brought here in this case because it is negative report. So the staff nurses, three witnesses who are staff nurses, they give evidence, of course, about the examination of the victim and the examination of the accused, but then at the same time they also stated about the ratio of their biological samples and red blood for DNA analysis, but that is of no use. So their evidence is of no relevance. And we have another doctor, PW10. who had examined the accused. This PW10, he said, it is the police's own position that he should examine if any injury is suffered by the accused and also to record his statement. So it is a prosecution move by themselves to get the statement from the accused. But that statement recorded by the doctor, it shows by PW10, it shows he negated all the allegations. Rather he said he admitted having met one lady, but he said we just sat on the stony area and had liquor together. Then the son came and they split ways. They separated. They split ways. They go their own ways. So this statement of this accused before the doctor, it seems to have been corroborated by the evidence of the victim's son himself, who admitted at the end and in his initial statement that it is a fact. I've only seen my mother sitting together with the accused. So it is none other but victim son himself supporting the statement of the accused. In this case, there is benefit of doubt against the accused. He is entitled for benefit of doubt. And the IO, of course, this WPSI is of me. She is only registering authority and taking precepts where she had just broken medical evidence of the victim and seized the biological samples of the victim. But that also has no relevance anymore because no scientific evidence in this case. DNA analysis is negative. And Dio, she had only deposed about the formalities of her investigation. Whatever the IO has stated is just about the formalities. But the only point which is of relevant from the evidence of Dio is that she said the accused was evading arrest, and I have shown the photograph of the accused to the victim and the son and his friend, and they have identified he is the one. What is this? This move of Dio, I don't understand. Well, from yes, of course, collected the photograph, but then thing is this: the identification from a photograph of the accused. It could be I just don't. Nevertheless, since in the statement of the accused to the doctor, he admitted to have met one lady and had liquor together, though he didn't admit the allegation of sexual assault. So this identification by the victim, her son, and the son's friend from a photograph shown by the IO is found contradicted by these witnesses itself. When the victim herself said, I could identify the accused because I'd seen him. She was at the time of incident, she was 35 years. I could identify the accused as because I'd seen him when I was 11 years old, a big gap to see. And I've discussed at that age, most probably adolescence age of the accused is bound to change in appearance due to puberty. So even the victim's son, also he brought some contradiction regarding identification of the accused. He said, I came to learn from Vishal, his friend. And even Vishal, he said, it is the mother, it is the victim, it is the friend's mother, meaning victim, who had asked him, who is that person we have taken together? What is this? That identification also, that move, that investigation part of the IO also is of not any help to the prosecution case. In the premises, I found the accused is entitled to benefit of doubt, as because the prosecutor's statement is full of made-up story, full of contradictions, and full of improvements from one stage to another with non-believable stories of mention or whatnot stories you brought. And these are non-viable, impracticable rather. Okay, so recused is acquitted with benefit of doubt. Hey, applause. मैं भाबो bakini ka victim kato kanong kato ko ba melek ka kalakana na ko force ko ko me bhabo o kon jokaro uya kalakana la uparo jong kon jokaro u kalakana la te meyo ya kakabu ba ni agdating ka kis ba ay pasyain tingin hapan pala so na din kini wajib resyo balik kini jaikan so so okay so pass on accused Apollos followed simply is present with his learned divisiality Nikiti and thank you of your visit and additional BP of your visit judgment and order by pages is delivered and announced in the open court today by which the accused is acquitted with the benefit of the doubt. And be to take steps as directed in the order to take steps to all concerns as directed in the order of the judgment. Also, and the court and in the judgment learned DY CITTC yeah mentioned the learned the D and then you are part of prosecution you are part of this from LETC to present the victim of this case, the victim of this case, to see if she requires and counsel or on the well-being, and if she requires on her, the owner, on her well-being, and if she requires any compensation. And to assist and to assist and the case stands disposal on contest. We have another judgment, right? It's in the case of we have another case of Abu Mia. Where is he?
Ma'am, due to a miscommunication, both the accused could not remain present in court today, so I pray another date may be given, ma'am.
I need their presence. I need it.
Yes, ma'am.
For pronouncing this judgment, they have to appear before this court. What is the reason why they could not come?
They said it's not possible for them to travel like by 10:30 to reach court since there are no vehicle in their hometown. So they have requested me to ask for a short date, ma'am.
See, many a times this court is accommodating. They are late coming to court, not exactly at 10:30, because we understand the situation here. There is no public vehicle, there is no vehicle. We understand that situation. So it is not a must that they have to reach at 10:30. But they could have come if that is the ground.
There had been a miscommunication. They thought the matter is fixed on 8 August, not 8 July.
Why till 8 August? Who will fix the late? I don't delay the judgment. So will you represent them today? Will you represent them today, or I issue warrant against them?
So, ma'am, a short date may be given, ma'am. I contacted my this morning.
You will file representation?
I'll be filing, ma'am.
Okay. Applause assignment to order right now. Would you please issue as well? Okay. The first one. And accused persons, Apollonia and are represented by their petition. Okay, I will not give long date. Give me the date that they could come.
Next week, ma'am.
Next week. Next week, give me the date.
16 July, ma'am.
15 or 16? 15 or 16? 16.
16.
It's okay, but help. It's okay from prosecution?
Okay, ma'am.
Yes, 16. Yeah, and Monday, additional will be received and on absence of the accused persons, absence of the accused judgment. Yeah, judgment is ready, but on absence of the accused persons, the same will not be announced today. So it's 67,2026. Okay. You have to complete. Make sure. Go to
Yes, ma'am. Yes, ma'am. May I take a leave, ma'am?
Yes.
Good day, Anna.
Good day. There's no case, okay. Yes. We will go to possible.